Questions of religious freedom have become prominent in light of the 2017 same-sex marriage plebiscite and the recent Israel Folau case, leading to commentators from Mark Latham to the Grand Mufti of Australia to call for a Religious Discrimination Act. Hello and welcome to Politics Laid Bare with Tim O'Hare. I'm your host, Tim O'Hare, and today I'll be arguing that Australia does not need a Religious Discrimination Act, as it will not lead to greater tolerance of religion or a freer society. Now, I am aware that to many Christians, the prospect of a Religious Discrimination Act, at least on the surface, may appear appealing in order to protect their faith from some of the authoritarian measures of secular governments in recent years. However, I believe that it is Christians in particular who have the most to fear from a Religious Discrimination Act. So what is the Religious Discrimination Act? According to Paul Karp from The Guardian, the bill prohibits both direct discrimination, treating another person less favourably based on religion, and indirect discrimination, where an apparently neutral condition has the effect of disadvantaging people based on religion. Furthermore, the bill creates the position of a Religious Freedom Commissioner to sit on the Human Rights Commission. There are, however, concerns about a religious discrimination bill, leading to the founding of the organisation Just Equal. Spokesperson Brian Grieg argues that calls for religious freedom are just a smokescreen for LGBTI discrimination. Others, such as Liberal MP Tim Wilson, have backed a Religious Discrimination Act, but cautioned that it must not lead to the marginalisation of other groups. But it's not just secular advocates who are concerned with the proposed Religious Discrimination Bill. The National Catholic Education Commission is concerned with Clause 10 of the bill, which says that a religious organisation does not discriminate if it commits practices that may reasonably be regarded as being in accordance with the doctrines, tenets, beliefs or teachings of their religion. This phrasing is too vague and could give scope to secular judges to deem certain practices as not being reasonably in accordance with the teachings of the faith. For example, a court could rule that opposition to gay marriage is not essential to the Catholic faith, and therefore a Catholic school would not be permitted to refuse enrolment to a student of parents in a same-sex relationship. As Dr. Augusto Zimmerman writes, the Sex Discrimination Act is invariably used against men. The Racial Discrimination Act is invariably used against white people. We can therefore only guess against whom the Religious Discrimination Act will be used for. Freedom of religion is already protected in Australia through the Constitution and through Article 18 of the International Covenant on Civil and Religious Rights, 1966, of which Australia is a signatory. Freedom of religion is an essential right, just like freedom of speech, freedom of association, freedom of assembly, the right to privacy, and equality before the law. Now, it is important to note that these rights do not exist in isolation, and that they regularly intersect with each other. For instance, the much publicised Israel Folau case arguably involved religious freedom in his right to believe what he wants to believe, freedom of speech, his right to quote from scripture, and freedom of association, the right of Rugby Australia to terminate the contracts of employees who do not accord with the company's values. The difficulty of a Religious Discrimination Act is that it effectively creates a new right, the freedom from religious discrimination, which in effect is privilege over other rights such as freedom of speech, freedom of association, and equality before the law. As Zimmerman writes, adding religious people as an additional class of protected people further compounds the problem of the constitutional invalidity of laws that may already unreasonably impinge the freedom of political communication. Moreover, there are concerns about the appointment of a Religious Freedom Commissioner to the HRC. Since its creation, the Human Rights Commission has shown itself to be uninterested in freedom of speech and freedom of opinion, the case against the QUT students in 2016 being a prime example of the HRC's neglect for free speech. According to Angela Shanahan, these commissions have been used to actually narrow our rights. Zimmerman believes that rather than balancing out the commission by appointing a person of faith as commissioner, the commission could actually divide the religious community by appointing an unorthodox church leader as a tokenistic representative from the religious community. This person could use their position to promote their personal religious views, such as the belief that gay marriage is consistent with Christianity, against the religious mainstream. Zimmerman instead argues that rather than expanding the scope of unelected bodies and creating more discrimination laws, this government should enact legislation that would give effect to Australia's international obligations to protect religious freedom and in the context of other fundamental rights of the individual, including free speech, freedom of association, freedom of conscience, and the right to peaceful assembly. In short, rights are not awarded by laws or government commissions. They are intrinsic to our being. Instead of attempting to defend rights through more legislation, the Morrison government should focus on ensuring that its policies are consistent with the International Covenant on Civil and Religious Rights, while removing any existing barriers to human rights by abolishing the Human Rights Commission. In summary, religious freedom is essential, but it must remain something that is inherent to society and not something that is granted to us by the government. A religious freedom bill should not be legislated, as it could weaken other rights and be used against religious groups by secular authoritarians.